5 seconds from now. Learned Counsel for the Revisionist submitted that the revisionist was 17 years, 1 month and 1 days old at the time of the incident as per educational certificate. The Juvenile Justice Board has declared the revisionist as juvenile wide order dated 16/8/2022 and no proceeding is pending against the order. It is submitted that the revisionist is innocent and has been falsely implicated in the present case due to ulterior motive. It is further submitted that the FIR has been lodged by mother of the victim against the revisionist and father and mother of the revisionist under sections 376, 506, 323, 342, 120B IPC and under section of 3 or 4 POCSO Act. It is further submitted that as per high school certificate, victim was 17 years 29 days old at the time of incident. As per statement of the victim recorded under section 161 CRPC, she stated that the victim was in relationship with the revisionist since 1 year and they talked to each other by phone. There is no allegation of enticing away or compulsion for marriage as well as offense of rape. There is maternal contradiction between the statement of the victim recorded under section 161 and 164 of CRPC. The revisionist has no criminal history. The revisionist is in protective custody since 7/7/2022. It is further submitted that the finding recorded by the court below is against the social information report and is based on surmises and conjectures. It has been further submitted that there is no evidence to show that if the revisionist is released on bail, his release is likely to bring him into association with any unknown criminal or expose him to moral, physical, or psychological danger, or that his release would defeat the ends of justice. No such findings were recorded as to how he will come in contact with known criminals and how he will be exposed to moral, physical, or psychological danger, or that his release would defeat the ends of justice. Learned Counsel for the revisionist further submits that the revisionist has no criminal antecedent to his credit except the present case and is not a previous convict, nor is he associated with any kind of unsocial or criminal activities. There is no report regarding any previous criminal antecedents of the family of the revisionist. The natural guardian father of the revisionist has given an undertaking that if the revisionist is released on bail, he will keep him in his custody and look after him properly, and has assured on behalf of the juvenile that he is ready to cooperate with the process of law and shall faithfully make the juvenile available before the court whenever required, and is all ready to accept all the conditions which the court may deem fit. It has been further submitted that the Juvenile Justice Board as well as the Appellate Court have not appreciated the social information report of the probation officer in its right perspective and passed the impugned judgment and order in a cursory manner without considering the position of law, and have declined bail to the revisionist. The bare perusal of the impugned orders demonstrates that the same has been passed on flimsy grounds which have occasioned a gross miscarriage of justice. The judgment and order passed by the learned court below are illegal, contrary to law, and is based on the erroneous assumption of facts and law. The bail application under Section 12 of JJ Act 2015 has been rejected by the Juvenile Justice Board wide order dated 1/9/2022, observing that there appears a reasonable ground for believing that the guardian of the juvenile has no effective control over the revisionist, and there is a possibility of reoccurrence of the offense after his release. Furthermore, he has committed the heinous offense and indulged in his activity due to lack of discipline. The Appellate Court has also affirmed the order passed by the Juvenile Justice Board The appellant court, without considering the social information report of the probation officer in its right perspective as well as without returning any finding on the three exceptions, declined the bail to the revisionist and rejected the appeal after observing that the parents of the juvenile are unable to keep the juvenile under control. There is lack of availability of a consultant, and if the juvenile is released on bail, he is likely to go into association with known criminals. To examine the validity of the impugned order, it is useful to note the relevant provisions of the Act as well as the case laws relating to this subject. Stop. Hello aspirants, please subscribe to my channel to get all the dictations of the latest judgments of High Courts and Supreme Court. Thank you.